That IEBC did not conduct the repeat presidential election in 25 constituencies in the Nyanza region dominated the proceedings at the Apex Court. While the petitioners claim that a presidential election cannot stand without all registered voters getting an opportunity to cast their ballot, President Kenyatta's lawyers blamed the opposition for the violence that made it difficult for IEBC to execute its mandate.
Polling stations were gazetted in each of the 291 constituencies. Returning officers were gazetted in each of those constituencies. Polling clerks were all recruited, and more important, my lords, ballot papers were procured at taxpayers' expense.
Once it is shown that there was violence, then the proposition that the election was free and fair is negated. If, on the other hand, we hold that it is still possible to hold an election in those areas, then we must consider that it was possible to postpone the elections in respect of the 266 other constituencies.
Fred Ngatia saying Raila Odinga's withdrawal from the race was not procedural and thus inconsequential, a position shared by Attorney General Professor Githu Muigai, who says there is no complaint for the inclusion of Odinga on the ballot paper to warrant nullification of Kenyatta's de-election.
The effect was to vitiate or void the election that had been scheduled for 26th of October. What happened on that day was a mock election or a dry run.
If we were to nullify an election such as this one on the basis such as those that have been given, we will be rewarding the people sabotaging the Constitution.
Kenyatta's counsel also questioning the neutrality of the petitioners, especially civil rights activists John Jamue and Halef Khalifa.
That this petition before the Honorable Court, for the reasons I have advanced, is a waste of time. It was filed by 3 individuals who failed to even exercise their most civic constitutional right to elect a president of their choice, and they had wide choice of 8 candidates, 2 very high priests of the civil society. This petition is nothing to do with public interest litigation. It's an innovative and a powerful proposal for donor funding.
The petitioners also reported confirming alterations on Select Original Forms 34As as had been cited in their petition. The Chief Justice David Maraga questioning whether the alterations were significant enough to affect the petition's standing.
Were there any entries in those laws which are material to the election we are dealing with? And he has said no. Because if they were there, that, so many forms were transmitted in this machine, whereas in this one they are different. You know, that's something which could concern us seriously. That's why I was very particular whether or not the entries have any material or any difference in material with what we are dealing with.
Well, the president-elect has defended his re-election on October 26th as an exercise that should be upheld by the Supreme Court. The petitioners believe that it was a sham exercise, a mock election that must be nullified. Sam Gituku, Citizen TV, at the Supreme Court of Kenya.